the prison knew this, wouldn't that provide the reasonable suspicion that you argue was missing?
No, because it depends on — because of the breadth of the phrase possession of a deadly weapon, as this case illustrates. The record shows that the possession of the deadly weapon, and that's why this charge was not pursued by the state, was that he was pulled over at a traffic stop and he drove away. The deadly weapon is the car.
You're feeding into your adversary's arguments that what you're asking the police to do on intake or the corrections facility on intake is to investigate in that fine detail. They can't even look at the rap sheet,
no, they
see use of a deadly weapon and say, this guy could be dangerous?
No, Justice Sotomayor, the rap sheet does not contain that charge. What the rap sheet does show, and we are perfectly fine with them looking at the rap sheet, and it's in the joint appendix, the rap sheet says that he had a single charge, he pleaded guilty, he got a term of probation. There is nothing about that the jail would have had any information suggesting that he had some charge involving a deadly weapon, and that's why they themselves certified that there was no reasonable suspicion.
Well, is the rap sheet always available immediately? I thought it was rather common, correct me if I'm wrong, based on practice some years ago, that it would take maybe 24 hours, 48 hours for the wiretap, for the wire services and the Internet to report that he was wanted for questioning for some very, very serious crime in some other state. I mean, in my practice, at least, county jails were much more dangerous than penitentiaries because you don't know who these people are. Did you arrest them for traffic and then maybe some serial killer? You do not know.
Sure. First, that is not the view of the jails in this case. Remember, they apply a reasonable suspicion standard. They did not find any concern in their own policies, neither does the Marshal Service, ICE, with this prospect of some prior offense. As to what the rule is and how common it is and whether this works in practice, the jail here did look him up in the New Jersey Criminal Justice Information System. That's in the record. They're required by New Jersey law to do that. Every single one of these jails has computer access to the NJ, CJIS, and also to the NCIC. They just type in his identifying information. They were able to pull him up without any difficulty, and they've not complained that they didn't have enough information about him. They filled out a form saying there is no reasonable suspicion here. And remember, our rule only operates in a system, Justice Kennedy, in which the jail does have enough information. When our point is this, if the jail has the facts, as it did here, to affirmatively determine that there is no reasonable suspicion, which is what they decided about Mr. Florence, then it is an extraordinary intrusion on dignity and autonomy to strip him naked when they have no reason to do so.
Counsel, my understanding of the statistics, and correct me if I'm wrong, is that they get about 70 new people going through this process a day. Is there anything in the record about how much additional time it would require to look at each one, to look at their record, to determine which category they should fall into, to strip search or not, as opposed to having a blanket rule?
Sure. There is, because they do this already. It is not an administrative problem. They apply our rule today. Remember, Mr. Chief Justice, when he arrived at the Burlington County Jail, they did an assessment of him and determined that there was no reasonable suspicion. The jails in this case did pull up his prior criminal history, and they have no problem doing that. They apply our standard today. It is not a difficult one.
Remember, Mr. Goldstein, you've acknowledged that we have held that when you have visitors, you may be strip searched after the visit, and the same kind of close examination that you object to here. Now, your explanation why that is okay is that is voluntary.
I have two explanations.
That you don't have to have visitors. Can you really condition your having visitors on your waiver of your Fourth Amendment rights?
Yes. Block establishes that you have no right whatsoever to have contact visits. And so under Schnecklock versus Bustamante, of course, you can say, I voluntarily relinquish my Fourth Amendment right in exchange for this privilege. But I have a second.
Are you sure about that? You can condition certain privileges upon a waiver of constitutional privileges?
Yes, I believe I think that's a fair statement of the law. I do have a second point, though, and that is that the principal reason underlying Bell versus Wolfish's holding that those searches were reasonable is that it was essential to deter smuggling. And that deterrence rationale has much more of an attenuated relationship to this case. Remember that the inmate in that case was having a planned meeting with someone, and the representation of the government is that our problem is if you plan to have somebody come visit you and you're going to have a contact visit, you can plan for them to try and sneak something to you. This Court has set
Mr. Goldstein, there, of course, were guards there who were watching the visits, and as I understand that case, there was really no empirical evidence that smuggling came about as a result of these visits.
Well, can I just read to you what the Court said about that? Just so the Court did have a slightly different take, I think, and this is from page 559 of the Court's opinion, that there has been only one instance where an MCC inmate was discovered attempting to smuggle contraband into the institution on this person may be more a testament to the effectiveness of the search technique as a deterrent than to any lack of interest on the part of the inmate to secrete and import such items when the opportunity arises. And our point is that when you have an unexpected arrest here, remember Mr. Florence showed the paperwork that he was not wanted for arrest, and that's going to be generally true in all kinds of traffic stops and the like.
But which is it you're doing? I mean, imagine, I thought you were saying you always need reasonable suspicion. So I imagine a case where the person is going to be arrested, put into the general prison population, there's a warrant out against him for second-degree murder, and the policeman stopping him for a traffic offense arrests him because he knows he's wanted on a warrant in another place. And the jail has a policy that says when you come in here because of second-degree murder, we strip search you. Okay? Can they do that under your rule or not? That's all they know.
Yes.
And you do not want it. Then you are not saying it always has to be reasonable suspicion.
It's just a debate about words. We think that is reasonable suspicion.
All right. Well, that isn't helping me.
I'm sorry.
What helps me is to know what the category of things is that the jail, in your opinion, is going to have to look into the characteristics of this individual person. And when I look at the ABA, they talk about minor arrests.
Yes.
And when I look at some of the cases, there's a long list like violence, drugs, and so forth, where you don't have to, where you can just use the fact that he was arrested for the thing. But there are other ones, minor ones, where you do. Yes. So what's your rule on that?
Our rule that we would accept is that with respect to minor offenders, that's when you assess.
Okay. Then the next question, which we'll get.
Yes.
Who is a minor offender and how do you administer that rule?
Okay. I think that is a great question for them because that's their rule. They have a rule that says for minor offenders that you have to have reasonable
But you are trying to state the constitutional rule, and you keep talking about what is their rule, and we're trying to find out what are the limits of the rule, and I think you've already qualified what you said opening. Opening, you said reasonable suspicion is the rule for everyone, the felon as well as the minor offenders. Now you seem to be saying, well, this case involves only minor offenders, so let's limit it to that. That's what I thought you were saying now.
Yes, that's right. Because this case only involves minor offenders, we have articulated a rule with respect to minor offenders.
Now, that's what unfortunately, I'm asking you and not them. And it's the same question.
Yeah, sure.
How do you want us to write this so that jail personnel all over the country have to be able to follow it and know exactly what they're supposed to do?
For 3 decades, the rule that was articulated by the federal courts and applied without difficulty is one that says for minor offenses. When that was applied in practice, it was basically done at a felony versus misdemeanor line. The court accepted that if you are suspected of a more serious offense, then for administrative reasons and because we just think you might be engaged in more criminality, then you don't have to have any individualized inquiry whatsoever.
I can understand that for cavity searches, but why for the search to see that if the person has any fleas or cooties or, any other communicable disease before he's put into the general population? Are felons more likely to have those than non-felons?
No, they are not.
So that line makes no sense for that aspect of the search, which is just we want to make sure that we have a clean prison.
That is not correct. That aspect, what the testimony in this case establishes is that the jail guards allow any sort of medical rationale for the search to be conducted by medical personnel, not by the guards themselves. All these inmates are examined by a medical person, a nurse, or the like, and they are responsible for
and that's where the Fourth Amendment invasion of privacy line is to be drawn. If you're examined close up by someone who has a medical degree, it's okay. And on the other hand, if it's someone who does not have a medical degree, it's not okay.
That is
That can't be the line as to whether your privacy is being invaded.
It can be the line, and it is the line that's been accepted for decades.
Even for
You
body
would
lines?
have to keep the person in custody, say, for 24, 48 hours until the medical personnel could come. Do you have 24-hour medical personnel for intakes that are 2 in the morning?
Yes. The intake process, the testimony is...
But
You're telling us that every county jail in the United States has medical personnel on duty 24 hours a day ready to do a search.
No, I apologize, Justice Kennedy. I'm telling you what's in the record in this case, and that is...
Said before was 2 feet is too close, but 5 feet's okay. Are you sticking with that?
Justice Breyer, I'm saying that a close inspection, which is intended to examine the person's individual genitals, and whether it's at 2 feet or 4 feet, I don't think is the relevant line. If I could make one point and then reserve the remainder of my time.
May I just ask, in your medical personnel, children in school get inspected for head lice, prisoners for body lice. You don't need a doctor to do that.
No, that's right. But if that is right, what happens is that medical professionals are the people who are assigned that responsibility. That's the testimony in this case. The only last point that I wanted to make.
But that's not constitutionally required.
I agree.
So that's another thing that you don't need to they can inspect for body lice. And that's okay.
If that's what they're doing, I think that is okay. The courts have said that is not itself because of the prospect of handling that problem with shampoo, which is what these jails do, that's not a sufficient justification to require the person to strip naked. The only other point that I did want to make is that this is the rule not just of Burlington and Essex, but also of the U.S. Marshal Service, which has the intake of 220,000 inmates every year, and also of the Bureau of Immigration Customs Enforcement, which intakes 384,000.
But the government tells us that that's true only if they don't put the arrestee in the general population.
That's not correct. That is only the policy of the U.S. Bureau of Prisons, which has an intake of minor offenders of only a few thousand people a year. For the Marshal Service and for ICE, which have a combined 600,000 people every year, they do not have that separate housing rule, if I could reserve the room.
Well, we'll give you rebuttal time, but maybe just to be clear,
yes.
Do you or do you not have an objection to the superseding ECCF policy?
We do, because they still have to stand naked directly in front of the correctional officer under the superseding policy. What the superseding policy is, which is Burlington's policy throughout this, is that they will not search the person for contraband, which is their supposed interest here, for contraband, in the absence of reasonable suspicion. Both jails, at the time of this search, and also now, will still require the person to strip naked, supposedly for contraband, even though their own policy says we won't engage in the depth of search that's required. We won't look at the anus. We won't look in the person's mouth in the absence of reasonable suspicion.
That's the current policy.
That is the current policy.
And you have no problem with that?
We do have
you have no problem with the reasonable articulable suspicion aspect of the body cavity search?
That's correct.
Okay. And with respect to the simple strip search,
yes,
your only objection is that the guard is too close to the inmate.
That's right.
Okay. Thank you. Mr. Phillips?
Thank you, Mr. Chief Justice, and may it please the Court. I actually appreciate the clarification that your questions brought to this case, because I think there's a bit of confusion that I'd like to try to clear up, although my colleague's movement in terms of answering some of the questions left me a little bit perplexed as to exactly what the nature of their claims are. The first question that it seems to me the Court should focus on is what policy is at issue here. And obviously, since the class certification deals with one set of issues and the plaintiff's claims deal with another set of issues, I think you have to be careful. I think you have to focus on the policies that existed in 2005. That was the basis on which he was, in fact, searched under these circumstances. And the policy in Burlington was primarily aimed, frankly, at health and tattoos, and the policy at Essex was aimed primarily at contraband and then secondarily at tattoos and health. And the policy at Burlington was largely you come into prison, you give up your clothes, they look through your clothes, you take a shower, they examine you fairly